You've lost someone, and now you're stuck asking the question no one wants to have to ask. Do I even have the legal right to file a wrongful death claim? It's painful enough having to grieve the loss of someone, without the added stress of having to figure out, am I the spouse, the parent, the child, or someone else that the law is even going to listen to? Hi, I'm Ted Spaulding. I'm a Georgia personal injury trial attorney, and I've walked this road with families just like yours. In this video, I will break down exactly who's allowed to file a wrongful death claim in Georgia and how the courts divide the recovery, so you don't get caught off guard by rules that can feel cold and confusing. Because the last thing that you and your family needs is to miss out on justice and compensation that you're legally entitled to. All right, let's get straight to it. If you're watching this video, you might have just lost a loved one, and you're wondering who can file a wrongful death claim in Georgia. Maybe you're a spouse, you're a parent, you're a child, or you're even a close friend. The rules about who's allowed to file are actually pretty clear in Georgia, but there are some twists that can catch some families by surprise. So let's break it all down step by step. By the end of this video, you'll know exactly who's eligible and who isn't to bring a wrongful death claim under Georgia law, and why that matters for your family's future. Georgia law puts the spouse at the top of the list. If the person who died was married, their spouse has the primary right to file a wrongful death claim. Let's say your husband or wife was killed in a car accident with a drunk driver. As the surviving spouse, you have the legal authority to bring the wrongful death claim on their behalf. You're the one who can file the lawsuit, speak for the family in court as the actual plaintiff, and if there's a settlement or a verdict that comes through, you receive the money awarded. Now, there are important twists to this. And the big one is the spouse, while the primary person that's allowed to bring the case, is not the only person who is allowed to share in the recovery, meaning either the settlement or the verdict. If the deceased had any children, the children share in the recovery. So what ends up happening is the law says that the spouse can receive up to 1/3, so meaning no more than 1/3 of a settlement or verdict in a wrongful death case. The rest, 2/3, goes to the children. And as that says, it's 2/3 for the children that's split amongst all the children. So if you have 10 children, it's 1/3 to the spouse, the 2/3 gets split evenly amongst the 10 children. Now, it's much easier if the deceased had no children. Then all the proceeds of the wrongful death claim go to the spouse. What if the person who died was not married? In Georgia, the next in line to file a wrongful death claim are the children. Any biological or legally adopted child of the deceased can file a wrongful death claim or lawsuit. So let's imagine a man named Victor dies unexpectedly, and he's never married. He has 2 adult children, Julia and Cassandra. And either of them would have the right to file the wrongful death claim. They can either file together or one can file on behalf of both. It does not matter if the children are adults or minors. All children have the same right. If a child is under 18, a representative would have to file the claim on the child's behalf for the wrongful death of the parent. Now, I'm often asked, well, what about stepchildren? Well, this is where it gets tricky, because if a stepchild has not been legally adopted, they do not have a right to file a wrongful death claim or to share in the proceeds of a wrongful death claim of their stepfather or mother. Now, sometimes families aren't close and disagreements can happen, but what you got to remember is if they're a legally adopted child or the biological child of the deceased, they have rights as to the surviving family member, the father or the mother. And it's not just one child. That child is entitled to any or all of the compensation. So if you have one child, that child receives the entire proceeds. If you have multiple, then it is split amongst the children because there's no spouse. So unlike the first scenario where they're getting 2/3, the children are evenly splitting 100% of the settlement or verdict in the wrongful death claim. If someone dies and leaves no spouse and no children, Georgia law turns to the parents, if any, of the deceased. The parents of the deceased are then granted the right to bring a wrongful death claim or file a wrongful death lawsuit. This applies if the person who died was a minor or even an unmarried adult without children. It does not matter. The courts typically will look and expect that the parents are going to share the proceeds equally, even if one actually files the lawsuit and not the other. So it's a lot like when the earlier scenario with children. One can file on behalf of all. One parent can file on behalf of both parents. So, for example, let's say that your college student, her name is Alexis, and she is in a tragic accident. Obviously, college student, probably not married, probably doesn't have children. If she has neither of those, we look to the parents, and the parents can file the wrongful death claim. Now, what if both parents are divorced or separated? Either parent can file. So again, remember, it's just like with the children, either parent can file, but the court requires them to split the proceeds unless they agree otherwise. So unless there's an agreement that one parent will not take any of the proceeds and give it all to the other, then they need to split the proceeds of any settlement or verdict. Now, what if both parents also have passed away, or if they've declined to file? Sometimes that happens. Then we move to the next category. If there's no surviving spouse, no surviving children, and no surviving parents, the right to file a wrongful death claim or to file a wrongful death lawsuit goes to the personal representative of the deceased's estate. This is often called the executor or the administrator of the estate. Let's say an elderly man named Frank dies in a nursing home. He was never married, never had children. His parents have predeceased him. In this situation, Frank's estate can file a claim. The person named as executor in his will, that would be the person who can file the lawsuit on behalf of the estate for the wrongful death. Now, if there's no will, then it would be the administrator of the estate, which would be a county administrator set up by the court because there was no will. And of course, we've already gone through, if we're at this stage, there's no next of kin. So we have to establish an estate, get a personal representative or executor, which would be a county administrator, and then that person can file the claim or the lawsuit on behalf of the estate for the wrongful death. Now, any money recovered goes to the estate. So again, if we have a will, then the proceeds would go as an asset of the estate to whoever is named as the beneficiary, in essence, in the will. Who did the deceased want to have assets? If there's no will, then it would go next of kin. And if no next of kin, then what's called the estate. They would get the proceeds of the wrongful death claim at that point. Life isn't always that simple, and neither are families, as we know. I want to cover a few scenarios that often come up that raise questions. So the first one is, what about an unborn child? In Georgia, the death of a quick child, that is a baby that is developed enough where it's moving in the womb, can have grounds to file a wrongful death claim. So if the baby is lost either at birth or in the womb and someone was negligent, there could be a wrongful death claim for the death of that child. And of course, that would have to be filed by the parents, one or both. Another scenario, let's say relationships are estranged, and this happens a lot, or the surviving spouse or parent hasn't been involved for years. The law usually doesn't care. This is all about legal status. So you can have scenarios where a parent hasn't been involved in the deceased's life for 20 years, but if they're the only party that is available, going down the line of who's first, then that parent, regardless of not having spoken to the deceased in 20 years, has the legal right to file the claim. It's the same with children. It's the same with spouses. Let's say you guys never got legally divorced, but were separated. I've had some where they're separated for 10 years. Well, if that other passes away, then the spouse is a spouse. Legally, they are a spouse. They have the right to file the wrongful death claim. Does not change. Another difficult scenario, we talked about stepchildren and also long-term relationships that aren't legal. So whether that is same sex or we're doing a common law marriage, which doesn't exist anymore in Georgia. You guys have considered yourselves married, have told people you're married, but you weren't legally married. The law does not care about that. Again, it's about legal status. You must be legally married to be considered the spouse. Stepchildren, unless you've been adopted, you are not considered the actual child for legal status to be able to file a wrongful death claim. It's real harsh, but this is the reality that we're dealing with right now with Georgia law. Finally, what happens if there's multiple people who are eligible, but they can't agree? This is a difficult scenario. For instance, children. It does not matter unless they legally renounce their rights. Anyone has the right to file the wrongful death lawsuit, for instance, or file the claim. They'd be doing it on behalf of all the others as well. They cannot just say, well, they didn't come forward, they're not owed anything. No, if they have the legal status that they have a right to the wrongful death claim, anyone can file it that does, and they all have to share in the proceeds. So unless you go to, and oftentimes this happens with estranged children. So let's say you have 5 children and 2 of them are estranged for years. So the other 3 file and think because the others are estranged, they don't have to receive any of the proceeds. That's not true. They would need to go to those 2 children and say, look, it's really not fair for you to share in mom or dad's death because you haven't been involved for years. Mom and dad wouldn't want that. They would have to agree and do it in writing that says that they do not want to share in the proceeds. They renounce their rights to any of it. If you don't have that, they absolutely have a right to participate in the proceeds of a wrongful death claim. So let's walk through a real life example to show you how this could work. So suppose a man named Charles, he dies in a truck driver accident. The driver runs a red light. Charles leaves behind a wife, Linda, and 2 minor children, Mia and Marcus. So Linda, as the spouse, has the right to bring the wrongful death claim or lawsuit. Under Georgia law, she has a right to recover a third of a settlement or a verdict. Mia and Marcus share the other 2/3. They do that through a legal guardian for them. So that would be Mia or setting up a guardian to represent the 2 of them. Now, let's imagine that Charles had no spouse, so it's just Mia and Marcus who are now the ones that can file the wrongful death claim, one or both of them. And then any money they recover would be split between the 2 of them. Now, they would have to do this because they're minors through a legal guardian again. This would have to be a court-appointed person, or if there's another guardian, that natural guardian, if you will, grandmother, grandfather, something like that, they can bring the wrongful death claim on behalf of the child or both of the children. And again, they then split. Now, what if Charles died? He had no spouse, no children. Mia and Marcus passed before he did, and there's no parents. Well, then an estate would have to be set up. Maybe he had a will. If he didn't, then a county administrator would have to get involved, set up an estate, and then they could pursue the wrongful death claim on behalf of Charles. Now, you may be wondering, having heard all this, why does the law do it this way? Well, it's all about making sure that the people most affected by the loss have the right to seek justice. And also, the law wants to keep it simple. They want to keep fighting from happening amongst family, and therefore delineate exactly who has the right to bring the claim and who does not. Because as you can imagine, the law only wants one lawsuit being filed if that comes to pass, and obviously one claim as well. They don't want all these different family members all filing lawsuits. Now we have a mess on our hands. It delineates it, makes it very simple, and allows people to understand exactly who and who does not have the claim, and also who gets to share in the proceeds. Because as you can imagine, that's where a lot of fights end up happening. The law tries to spell it out so there can be no misunderstandings amongst multiple parties who want to have the right to bring this lawsuit or file this claim and seek justice. Sometimes families get along and want to do things differently. Maybe all the children agree that just one sibling's going to file, or all the parents agree that mom will handle the wrongful death claim. Georgia law allows this as long as everyone agrees, they're on board, and the proceeds are split the right way. But be careful. Things can get messy if someone changes their mind down the road or if the paperwork is not done correctly. That's why it's so important to talk to a lawyer who knows Georgia's wrongful death laws inside and out. If you've lost someone and you think you might have the right to file a wrongful death claim, the most important thing to do is act quickly and get good legal advice. There are strict deadlines in Georgia, usually 2 years from the date of death. But sometimes, if there are special circumstances, it could be even less time. Don't wait. Evidence can disappear. Witnesses' memories can fade. Video evidence can go away within the first 30 days. The other side in a wrongful death case, you can be sure, is going to start building their defense very, very early. So the sooner you talk to an experienced Georgia wrongful death lawyer, the better your chances are of protecting your family's rights and the financial future of your family. All right, so let's recap what we've covered. Number 1, the surviving spouse gets the first chance to file, but shares proceeds with any and all children. Number 2, if there is not a spouse, the children step in. If there's no spouse, no children, the parents get the right. Number 4, if none of those are existing, then the estate's personal representative has the claim. And 5, finally, special situations like unborn children or estranged family members have their own rules, but legal relationships always come first. It's all about the legal relationship. Keep that in mind. If you're unsure where you fit or your family has a unique situation you're not sure about, don't gamble with your future. Get a clear answer from someone who's handled these cases before. You now know exactly who can file a wrongful death claim in Georgia. But here's the thing. Your next steps are just as important. If you or someone you know has been hurt in a car accident, there's a single mistake that can ruin the entire claim before it even gets started. Don't risk it. Watch our next video, The Wrong Move That Can Destroy Your Car Accident Injury Claim, speaking to the insurance company before a lawyer. I'll walk you through exactly what to say and what not to say so you don't lose out on the compensation that you deserve. Click through now, protect your family, protect your rights. I'll see you over there.